Okay. Happy Wednesday, everyone. For those who haven't met me before, my name is Alexis Alvarez. I am the Director of Statewide Training at Florida Legal Services. And today we have a very exciting training for you all. And I think that excitement is shown in the registration. We had about 133 people registered for this event. I see we have about 30 that have trickled in so far. I know it takes folks time to hop on and log on. So I'll take up a little bit of airtime with some housekeeping before we get into the meat of things. This program is Introduction to Probate for Legal Aid Lawyers. And it'll run until about 1:30. If folks have to drop off early, if you want to stay longer, as long as our speakers have the time, stay around, or if you need to drop off, a copy of the recording will be sent to everyone who's here live and everyone who registered. So this is being recorded and you will get a copy of that recording. The recording will come from Zoom, an email from Zoom, not from me, but I'll drop my email into the chat. Just in case you don't get that Zoom email, you can always reach out to me directly. So second housekeeping announcement is this was approved for CLE credit. We earned 1.5 general CLE credits for this wonderful presentation that you're going to be a part of. So I will announce that CLE code out loud. I will also drop that CLE code into the chat. It will also be included in the follow-up email. So don't worry, you'll get it. And of course, you can always reach out to me directly if you don't. Last piece of housekeeping is questions and answers. So this training is going to be broken up into a couple of different parts, all touching along probate and then guardianship work. So if you have any questions basically drop your questions into the chat as they're coming up. And as they pertain to the first part of this training, there will be a pause moment where I will be able to present your questions out to the speakers. And then we'll also have another opportunity at the end to also present any questions on the second part of the training and the subject matter. So as your questions come up, please drop them into the chat or the Q&A. I will be monitoring both of those and I will make sure that your questions get heard. So the boring stuff done, I will move into introductions of our speakers here today. So today we have Giovanna Abreu O'Connor, who is the managing attorney in RMO LLP's Miami office, which she helped launch. Gia's practice focuses on representing beneficiaries and fiduciaries such as administrators, executors, trustees, conservators, and guardians in contested trust and estate and guardianship litigation, as well as related estate and guardianship administration issues. She graduated from Florida International University with a BA in International Relations. She then attended Florida International University College of Law, where she interned with the Probate Division of the 11th Judicial Circuit in Miami. We also have with us Elsa Van Borg, who is an attorney in the Miami office of RMO LLP. Having previously served as a Miami-Dade Assistant Public Defender, Elsa brings extensive trial experience and advocacy, skill in representing heirs, beneficiaries, fiduciaries, creditors, and other interested parties in litigated probate, contested guardianship, and elder abuse cases. Elsa graduated from the University of Minnesota with a BA in philosophy and received her law degree from Mitchell Hamline School of Law. We are very lucky to have both of these speakers here, both of these members of the private bar giving back their time to our legal aid community. So thank you both very much. And before I turn it over, I do see that the chat might not be enabled. I will get that enabled, don't you worry. The floor is yours.
Thank you.
Thank you.
Hi everyone, I'm Elsa. And we can go into our first slide.
As a general matter, probate is a very specific area of law. So you have an entire body of law that you're going to be dealing with in probate. And it's very important to know exactly where to go. And we'll try to give you as much as we can here in terms of a highlight 30,000 foot view overview of what the body of law for probate is. We're going to cover probate and we're going to cover some guardianship Just a caveat, this does not cover everything that you will ever encounter. We're just trying to give you kind of like a roadmap of where you can go to find answers. And of course, we're always happy to serve as resources to you. So if you ever have questions, feel free to reach out to me or Elsa, and we'll try our best to help you out. With that, Elsa, take it away.
Can you go to the next slide?
Oh, sorry. Yes, there we go.
All right, so in general, probate practitioners sort of work in two areas. We deal with cases involving someone who is alive but in need of some kind of protection or assistance in managing their assets or their day-to-day living. So the cases involving people who are alive are generally cases for determination of incapacity, to determine whether or not someone has the capacity to manage their personal daily affairs or their property and assets. And as a related matter, implementing guardianships or similar less restrictive alternatives, such as maybe a trust or a power of attorney or something like that, to assist them with their affairs. And then the third area is exploitation of elderly or vulnerable adults and implementing injunctions or having civil actions or sometimes even criminal prosecutions to try to protect people who are vulnerable. And those areas sometimes bleed into each other as well.
And then on the flip side of that, we have cases involving people who have passed away. And the first thing that we have is probate administration, and that really entails transferring people's assets that are left in their personal names and their individual names without anybody else or any survivorship or designation of beneficiary, and transferring those assets to the people who are entitled to them, whether through intestacy or through a will. And then there's also a trust administration. And trust administration can kind of cross over the living and the dead, because you have to administer a revocable living trust during somebody's life, and later on in their life, during their death, you have to administer it for the benefit of whoever the beneficiaries are. And hand in hand with those sometimes come will and trust contests. So we'll get into the reasons why you can contest them, but essentially people fighting over an inheritance, people fighting over who should be a representative or trustee. Perhaps somebody took something that did not belong to them and is not really administering a trust or an estate to the benefit of the beneficiaries for the heirs.
Okay, so as Gia mentioned at the beginning, there is an entire section of the statute book and the rules dedicated just to probate and guardianship cases and proceedings. So it is very specific, and most of the time, if you have a question, there's probably a statute or rule related to what you need to do, and it is a lot to learn and it's a lot to look through, but most of the answers are generally there. Obviously, there's case law to supplement it. So I'm just going to go through some of the probate specific law, and then Gia will cover some additional body of law that will apply to probate cases, and we'll do the same for guardianship. So the Florida Probate Code consists of Florida statutes chapters 731 through 735, and I've listed out each chapter's more specific titles, but this is where you're really going to be looking as far as statutes go for everything from what to do when you first learn that somebody has died, all the way through administering the estate and distributing the assets. And then to go along with that, if there's a trust involved, whether the person is alive or whether the person has passed away, there is a separate Florida Trust Code, which is chapter 736. And a lot of times you'll be going back and forth between the probate, the will section and the trust section if you have a trust involved. Other chapters that come into play with trying to determine what you need to do with certain assets and disputes that you might look to are chapter 738, which is the principal and income statute, and then chapter 198, which depending on the practice, you might deal with it yourself if there's estate tax issues. Otherwise, you might refer that out or have a specialist involved that is an expert in tax. And then the Florida probate rules. There are, I think, 5 parts, but the first 2 parts deal with the estate and trust part. The probate rules 5.010 through 5.530.
And then we also have case law, and that will sometimes shape the legislative body of law, and sometimes the legislative body of law will shape to the case law. And in wills and trusts, there's a lot of case law concepts and even statutory concepts that are interchangeable, because it's a very similar, I guess, the law of wills will sometimes apply to the law of trusts. And I believe the law of trusts is a little bit newer, so we borrow a lot of concepts from that body of law for trust law. And then we also have the rules of judicial administration. Those are just like in civil, going to govern service and kind of just administrative things like designation of confidential information, which is huge in probate, and that kind of, I guess, administrative thing, for lack of a better word. Then we also have the rules of evidence, and there's some that are specifically excluded in their application to probate, but for the most part, the same rules of evidence will apply. You're going to be admitting evidence the same way, making objections the same way. There are some specific hearsay objections that are more akin to probate, and vice versa, more akin to civil. So definitely we'll be using your skills from civil and perhaps sometimes even criminal that you learned in probate. So we also use the rules of civil procedure, but they're kind of applied sparingly. So if you're in an adversary action, you're going to utilize the rules of civil procedure. They're going to apply upon declaration or filing of an adversary proceeding. We'll get more into adversary proceedings later on. The civil procedure rules related to discovery, subpoenas, and taking testimony all apply in probate and guardianship proceedings, and they can be used by an interested person. So when I started practicing, we didn't have those tools as available to us, but there's been recent changes that allow you to do more expansive discovery in probate proceedings, and then the rules of civil procedure will apply. So to conserve assets of the estate, the court has broad discretion to limit that scope and place and manner of discovery, and to assess costs and fees against an attorney, party, or beneficiary. So they try to be mindful of the fact that we are in a usually in a non-contested probate administration. Sometimes it's contested and may not be an adversary, so they don't want people to just go on a fishing expedition with discovery and try to get things that they're not entitled to. So once a probate proceeding is adversary, the proceedings are as nearly as practical conducted similar to suits of a civil nature, including defaults, and that's under Florida Probate Rule 5.025B2. And the Florida probate rules and civil procedural rules will give you the scope of their application whenever the civil procedural rules kick in, and you'll be able to see what applies, what does not apply. And you'll see that at the very beginning, I believe, of probate rules, and very beginning of the civil procedural rules. We also have jurisdictional administrative orders. So indeed, we've recently had a lot of AOs that have come in regarding probate matters and family matters. So it's always good to keep up on those and make sure that you're in the know. Otherwise, you might get something kicked back or be embarrassed because a judge says, hey, you weren't aware of this. So always important to look at that, look at the local rules, if there are local rules, local forms, and local checklists. Checklists are something that has come about more recently, and each circuit is going to have their own checklists. Sometimes, not all have checklists, but Broward, Dade, Palm Beach, at least, all have checklists for probate matters, and you have to check off every single item. And I'll show you an example of one in the next slide. You have to check off every single item that is applicable to what you're filing to be able to have the judge consider your case. And if not, they'll kick it back and they'll tell you you did not comply with the checklist. And sometimes there's checklists that are tricky, so you have to be patient and sometimes creative. You may have to set something for hearing or send a letter to the judge and explain why something in a checklist doesn't apply. One example, recent example I've had is a checklist for distribution. We have a final distribution checklist that requires you to get waivers and consents of accountings, and sometimes people do interim distributions. So I've had to explain to a case manager or a judge and say, we don't need to provide you a waiver of accounting or a petition for discharge at this point because the probate hasn't concluded. There's still more work to be done, but we do need to get an interim distribution to this beneficiary or interim distribution to somebody for whatever other reason, the PR for payment of expenses. So we have to get this done, but not really at the latest stage of the case. The other thing to look at are judges' procedures. And I think in Dade, it's less common for a judge to have a very expansive procedure. But if you go to Palm Beach and some Broward judges, they will have very specific procedures on how they want proposed orders submitted, how they want courtesy materials submitted. So I always kind of check off my list of, have I complied with the probate rules? Have I complied with the statute? Have I complied with the local rules, AOs, and procedures before I submit anything? And then the next slide is one of these famous checklists. So here you see, this is all a court form. You can find these on the 11th Judicial Circuit's website. There's a little section called Probate Attorney Corner. And if you Google Probate Attorney Corner 11th Judicial Circuit, you should be able to locate it, along with some of the court required forms. So here you would fill in, obviously, the name of the deceased, the case number section for the judge, and your name as an attorney. And this is a formal administration test state checklist. You need to give them an authenticated copy of the death certificate. An original will needs to be deposited with the clerk of court. You need to file the petition for administration and make sure that it's in compliance with the rule, and waivers and consents, or show that you have served people with formal notice for the petition. So for the most part, these checklists in Dade at least will reference the statute or the rule number, which is very helpful for people who are not necessarily practicing probate every single day. And really, if it's not applicable, sometimes things are not applicable, like the notice of trust here, you just put NA. And you just check off each little box, and next to it, you'll see a blank where you can put in, or you're supposed to put in, the docket number. Dade now has docket number, so be mindful of that. They want to make sure that everything has hit the docket, it's been filed properly, it's been accepted. And then once you have all your supporting docs and all your requirements, you get to check off your proposed orders, which you'll see it says Form E2 or Form E4. These are all forms that are required by the court. You cannot submit your own letters of administration or your own order admitting will to probate or designating depository and similar things. You have to use the court forms, at least in Dade County. Not every county is going to be like this, so just be very mindful and take some time and look at the judge's procedures, look at the court procedures, because it will save you a lot of agony. All right, this is you, Elsa.
Okay, so before we even get to the official probate proceeding, there's a few things that you should be aware of or maybe start gathering information about. So before pretty much anything can be done with regard to figuring out who the beneficiaries are, what the case needs to look like in a probate matter, there has to be a death of the person whose assets we're talking about. So for example, you might know that your family member has a will, and that will, there's something kind of sketchy that happened with that will, but there's really nothing you can do about it until that person has died, other than maybe gather information and document things for evidence to use later on. And so generally, death is established by filing an official record of death or death certificate. And there are some specific timelines for different types of proceedings. I know in Miami-Dade County, that's something that you need to file right away in order to even really open up a probate case. But that's sort of specific to certain counties. There is a statute that more specifically talks about what the timeline is to file the death certificate or establish death, depending on the type of proceeding. And Florida Probate Rule 5.205 talks about that. Another issue that comes up, actually more than I would have guessed, is what happens to the body, or what is the burial going to look like for the person who has died. And if any of you remember, that was the primary issue that was discussed in the Anna Nicole Smith case. There were 3, and then there was like possibly a 4th person who were claiming that they were the person to make the decision about what should happen to her body. And a lot of times this comes up if, for example, someone has children and then they get remarried later on. There might be a dispute based on what the party believed that the religious preferences were, or what they always told their kids, but then what they always told their new spouse, something like that. So that does come up, and that statute is, the statutes that you would want to reference here are 497.005, subsection 43, and 732.804. And then the next step is there a will? Generally speaking, we'll get into this a little bit more, but you need an original copy of the will, meaning the actual copy that the decedent signed. And if there's only a copy, then that can lead to some litigation or additional probate proceedings down the line. That has also been a little bit more complicated by the development of electronic wills, and electronic wills are specifically discussed in statutes 732.521, 522, and 526. You also want to be aware of if there's like a separate writing in addition to the will, known as a codicil, that might have changed something or added something. And the original will needs to be submitted to the clerk of the court generally where the decedent resided within 10 days of learning that the person died. That is a lot of times not practical. And generally it's, if you learn about the will much later, or you know about the will and you don't know that they died until later than 10 days, there's generally not any consequences. However, it can come up, and attorney's fees or sanctions can be assessed if somebody knowingly has the will, knows that the person died, and doesn't deposit it with the clerk.
One other thing to keep in mind is with wills, sometimes people will say, if you find a separate writing disposing of my personal property, you can do that. You can have a will, and then a lot of practitioners attach like a blank piece of paper with lines with numbers, so that people then can go home and go through their jewelry or go through their valuables and list them out. And a lot of form wills will have a provision that says if it's not found, if that separate writing is not found within 30 days, the PR can assume that it doesn't exist. Just be mindful of the fact that that can appear and sometimes disappear. So if you have knowledge that there was a separate writing, that's maybe something to bring up to the court. If you don't have knowledge that there was a separate writing and you can't find it, then that 30-day window or whatever amount of days they put in the will kick in.
And I think this is probably, I don't know if it's something that you as legal aid professionals will come into contact with, but in order to prevent litigation later on, one of the most important things is to make people aware of, I have a will. It was done around this time. This is where it's located. These people know about it. The original is located in this place. And some of the most heartbreaking things that we see are really just a matter of a lack of communication or a lack of organization, and they create a huge mess for people after the death.
Yeah, and you end up having, there are mechanisms in the statute, and we don't cover that here today, but there are mechanisms in the statutes that allow you to, like Elsa said, admit a copy of the will, but there is a presumption that it's lost or destroyed. You have to overcome that presumption and show that the person did not intend to destroy it, or show that it's lost. Sometimes when everybody's in agreement, that's not a big deal. You get consents and waivers from everybody and the court admits it. And sometimes you have a hearing just to have the oaths done in live testimony. But you submit an oath from a witness to the will showing that there was a will signed, the original can't be located, it was done, and it is valid. But sometimes people use that as an opportunity to litigate. And we have a case like that now where the will is missing and we have people trying to establish a lost will. So it can create additional fees and additional delays for administering an estate. Are we ready for the next one, or?
one more thing on that topic is in some jurisdictions, like I know I'm from Minnesota, and in Minnesota, if I do a will today, I can bring it to the clerk of court's office and they will hold on to it there and it will be safe. And the most recent copy of the will, unless I can't get there or something, should be at the clerk of court's office. In Florida, at least as far as I have found so far, and I think, Gia, it's the same for you, we have not found any jurisdiction that will even accept a will at the clerk of court's office prior to death.
All right, so in terms of the probate process, this is a pretty general explanation, and I'm sure you guys understand this, but it's a court supervised process for identifying and gathering assets of a deceased person. You pay the decedent's debts, or you object to claims that are objectionable. You distribute the decedent's assets to his or her beneficiaries. And in limited circumstances, there's property that can be distributed without going through probate. And that includes things with designations of beneficiary, that includes joint tenants' right of survivorship property, tenancy by the entirety property. Anything that has a survivorship component is not considered a probate asset. Another thing is homestead, and we'll go through that a little bit deeper later on in the presentation. But some of these things are able to be administered without probate. Now, homestead is a little tricky. You still have to open up a probate, get a determined homestead. But if it's just a homestead, sometimes you can do a summary administration. And if it's necessary to do a formal administration, it's a simpler process, but you do have to have the court declare it as homestead if it's not jointly owned with someone, or if it's not tenancy by the entirety's property. When a person dies with property in his or her own name only, regardless of the existence of a will, you're going to have to probate that property. And the will is really, people think, oh, I have a will, I don't have to go through probate. That's wrong. The will is really just a set of instructions for the court on what to do with the property, how to distribute it, when to pay debts, and when and who needs to take care of the estate administration. So who's the personal representative, who's the successor, and sometimes it deals with burial rights and who gets to do what and how you get to bury somebody or cremate somebody. Property is usually distributed according to an estate plan, which can include wills, codicils, trusts, and different kinds of trusts, revocable, irrevocable, and other subsets of that. And other legal instruments like deeds with a beneficiary designation, or with life estate, like a ladybird deed that people talk about a lot. You have a life estate and you have the remainderment. So it's not really necessary to have to go through probate with these things, but it's another way, it's another estate planning tool that you can use. You can also, if there's no will, if there's no other estate planning tool used to distribute this property, the property is going to go through intestacy laws. And these are our gap fillers, obviously, for how things are going to be distributed to heirs and survivors.
So generally, or almost always, probate action is commenced by filing a petition for administration. The Florida statutes, chapter 733, has multiple statutes that walk you through what the requirements are. And then you also definitely want to look at rule 5.200 and 5.201, because they will lay out exactly what needs to be included in a petition for administration, what you need to make sure you checked for, and what you need to tell the court. There are generally two processes. There is a third, but we're not going to touch on that. For probate administration. So there's a summary administration, which is a shorter, simpler process, which applies so long as the decedent did not have a will that required formal administration, and that the total property of the value that needs to be distributed after creditors' claims does not exceed $75,000, or that the decedent has been dead for more than 2 years. So in either of those situations, as long as there's not a will saying formal administration is required, you're going to go through the summary administration process. And the summary administration process is set forth in statute 735-201 through 735-2063, as well as Florida Probate Rule 5.530. And then the other process is formal administration. So formal administration is going to occur in almost every situation where probate is necessary, other than where the property is less than $75,000 or the decedent has not been dead for more than 2 years. And that's where a personal representative is for sure going to be appointed, or some substitute for a personal representative. And that's generally where, if there is going to be some argument or contest, then formal administration is going to be required. An ancillary proceeding takes place either in this state or another state where somebody resided in one jurisdiction but had property in another jurisdiction. So, for example, if you were a resident of New York and you died in New York, but you did have a piece of real property in Florida, then an ancillary proceeding will need to be opened in Florida to distribute that real property in Florida, unless there was some kind of deed or something else to transfer the title of the property. Another consideration in what kind of petition for administration you need to file is whether or not the decedent had a will. So if the decedent had a will, it's going to be a testate petition for administration, and if they did not, it will be intestate. And generally, there is a statute that lays out when it would be different, but generally the venue will be in the county and state where the decedent resided or was domiciled at the time of their death. And then the last thing related to venue is that probate proceedings are in rem proceedings. So again, if there's a piece of real property in another jurisdiction, such as another state, you're not going to be able to deal with that in the Florida probate case. That will have to be dealt with in the jurisdiction where that property, the real property, is located.
I think the third one that you didn't mention also was a disposition without administration, which is less common for us, but it may come up for a legal aid practitioner. So I'll just address it very generally. When the assets in an estate are not more than the amount of the preferred funeral expenses or the last hospital expenses, you can do what's called a disposition without administration. It's generally done by affidavit, and you submit certain proof of what the funeral and hospital expenses were so that you can ask the court to distribute that. I have used that once in my 10 years of practice to help an elderly person who didn't have as many resources and needed to get his aunt, of whom he was the only heir, his aunt's bank account that was under $5,000. And he had paid for her funeral. So we were able to show the funeral bill. We were able to submit a letter in affidavit form to the court and get the court to enter an order directing the bank to give the money to the heir. So in circumstances where you see that maybe a summary will take care of that, but if you see that you need something a little more simple and you can qualify the amount under one of those two provisions, either the funeral expenses or the hospital expenses, you will be able to use that. And that's at 735.301. All right, so the next thing I'm going to talk about are some early issues that happen in probate proceedings. And one of them is a caveat. And a caveat can be very useful for two reasons, where somebody thinks that they may have been disinherited inappropriately and they don't want, let's say, mom, dad was taken advantage of by someone and drafted a will at the end of their life that they couldn't challenge during the person's life, but they want to make sure that nobody goes around that potentially interested person, heir, or beneficiary, and you file what's called a caveat. A caveat is a notice that you place. You can do it before the person dies if you're an heir or beneficiary, and after the person dies as well. And basically what it does is it requires the clerk of court and anybody who files a probate administration to give you notice of the proceedings before a PR is appointed. That way, even if you're disinherited in the will and they don't consider you, and some attorneys think, oh, this person's disinherited, I have a will, I don't have to give them notice because they're not interested in the will. Even if they take that position, the clerk is going to send you a notification via certified mail, usually, that there is a probate proceeding that started and that you have X amount of days to object to the petition. So they're not going to get a PR appointed unless that caveator is notified. The other people who can file caveats are creditors. That can only be done after that. So as a creditor, if you file a caveat, you're going to get notice of the proceedings, and you probably, if you were a known creditor, you're probably going to get a direct notice of creditors served upon you by the PR if they're doing things correctly, or you're going to have to find out about it if you're not reasonably known or ascertainable through the publication that gets done in the newspaper. And we'll get into that in a second. But these are the two parties, and there's very sensitive timing on that. So just be mindful of what kind of party, if you are representing a party that does need to file a caveat, what kind of party they are and whether they can file before and after or after the death. The other thing that comes up, and I've had this come up and it can be daunting, is locating beneficiaries or interested parties. So the first thing that you'll do is you're gonna do a docket search, make sure nobody's ever filed a probate proceeding. If you can't locate someone who you know was in the county, chances are you may find a lawsuit or divorce or some sort of other proceeding that may lead you down the crumb trail of finding this person. Most judges will allow you to do notice by publication if you've shown a diligent effort to locate an heir or beneficiary. And in my experience, I had a very sad estate with a disabled young woman who was hit by a car. Her mother and father were estranged. They were not married. He lived in Columbia. She lived in Tampa. And she wasn't really keen on giving us a lot of information about the father's whereabouts. So what we had to do was hire an investigator and do a background search to be able to locate or try to locate the father and show the court that we did try. And in doing so, we employed an investigator to do that, and we did an affidavit of diligent search. Once that affidavit of diligent search was filed with the court allowed us to publish notice to the father or future father to give him notice of the administration. Otherwise, the mother couldn't get appointed as personal representative because they have equal priority. And at that point, it would have just cost her a lot more money to set it for hearing and do all this stuff without being able to locate the dad. So you can also employ sometimes what's called an heir search firm, and be very careful with heir search firms. A lot of them are not what you think they are. Some of them will be very helpful, very diligent, and they will find people for you. There's some that come out of the woodwork. I had one in particular where we were administering an estate for someone who we thought only had a niece and nephew alive, and an heir search firm came out of the woodwork, hired counsel on behalf of the unknown heirs, and found 3 elderly women in Austria that were somehow related to, they were half sisters of the decedent. And unfortunately, the decedent was a product of rape and didn't really want anything to do with that side of the family. So it ended up turning into a court battle. And that's, I guess, the less positive side of what heir search firms can be involved in a probate proceeding for. And then the other option is if you can't locate the person and the court doesn't want to give you the ability to publish notice for the person to know what the probate proceeding is going on, you can hire, or the court can appoint an attorney ad litem for that person or a guardian ad litem for that person. And the difference is the guardian ad litem is really going to render a report and say, we've tried to find this person and we are not having any luck. The attorney ad litem is going to be able to take a legal position on behalf of that person and defend anything and take care of any argument or any objection that that person could have been able to make. Notice in probate is usually done even at the beginning of the case. We don't necessarily have to use a process server. You can do certified mail and send things via certified mail. But there's something called formal notice that is really a creature of probate law, and that's in the probate rules under 5.040. It is required in some circumstances, but it's optional in others. And sometimes it's a strategic decision because you serve somebody with formal notice and it gives them 20 days to respond. And even though you're not required to serve the particular petition via formal notice, you may want to do that anyway, because upon that 21st day, you can go into court and get your order and not set it for hearing. So that's a really useful tool for probate practitioners or even people who are handling a probate case here or there, because if you know that somebody's not interested in something or going to respond to something, but you still have to get things done and they're not necessarily going to sign a consent, you can just give them the formal notice, give them the 20 days, and on the 21st day, you go on court map and you submit your orders, and hopefully they'll get signed if everything else is in order. But it's a really useful tool. I learned about it early on in my career and I use it a lot. Sometimes in lieu of formal notice, you can have people sign what's called a joinder, consent and waiver, or sometimes called a consent and waiver or a consent. So they can either join in the petition and consent to the petition and waive hearing and notice thereon, or they can just consent and still require you to notify them, or they can do the joinder and consent or joinder and waiver. So it's a lot of people call them consents, but there are different components to them. So if you do just a joinder and consent, you still have to serve the person with notice or have a hearing. So keep that in mind when you're handling this kind of case.
Just to touch on one more thing on that last slide. There was a question about who would handle the attorney ad litem's fees, and we are going to get into fees and costs and things like that, but just to answer that, since it's really relevant to this slide. In general, the estate would pay for the fees, but that could be challenged by the beneficiaries depending on how helpful the beneficiaries believed the attorney ad litem was and how appropriately they acted.
And probate is a court of equity, so unless there's something that is absolutely required to be paid by someone or something, or is absolutely required to be assessed, the court has a lot of discretion. So if they find, like Elsa said, that an ad litem wasn't helpful, they might slash the ad litem's fees in half or in a portion, or they may say this one particular person who asked for the ad litem has to pay for it, or it comes off the top. So it really depends on the circumstances, but there is a lot of leeway and a lot of discretion that probate judges have. Keep that in mind too. All right, next slide.
Okay, so I think something that's unique about probate and guardianship cases is that unlike a lot of civil cases and criminal cases, you're not just dealing with a plaintiff and a defendant, or a plaintiff and a defendant and a cross plaintiff or something like that. There are a lot of parties that may come into play, and sometimes it's just the personal representative, maybe only, or maybe a personal representative and the beneficiaries all tend to agree and there's no dispute. So it can vary a lot. So there are several statutes about who should become the personal representative, who has preference in appointment, who's qualified, who's not qualified to be a personal representative of an estate. So if there's a will in general, the will name a personal representative. And a lot of times, if that person can't serve for some reason, they'll name a successor or alternative personal representative. And in general, that person is favored to be the personal representative. If there's not a will, or the person named is unable to serve, the statutes list priority to go down on who should be appointed. So that generally would be the surviving spouse, or if not, a surviving child, and it goes through a number of people. In order to qualify to be a personal representative, you have to be 18 years old. You cannot be a convicted felon, and certain other factors will be taken into consideration as well. And I would say a lot of disputes include or involve who will be the personal representative, whether that's because they're disputing that the document is valid that names the person nominated as a personal representative, or because there's some other issue going on, that maybe there's a conflict of interest alleged or something like that. So in addition to the personal representative, let me just touch. One way sometimes to resolve disputes about who should be the personal representative is to appoint two people. So maybe you appoint the significant other, and then a friend or a family member that one of the beneficiaries would trust and agree to, so that there's some say there. And that will a lot of times just eliminate some of the conflict. So a trustee is another person, or co-trustees that could be involved. If there's a trust, it could be a professional like a bank, or it could be an individual like a spouse or a child or a friend. Sometimes the court appoints an administrator ad litem or attorney ad litem or a guardian ad litem, especially if there are minor children involved in the case, or if there are issues where maybe the personal representative has a conflict as to one very specific issue, but not generally as to others. There might be an administrator ad litem appointed by the court. And again, generally speaking, those fees would either be paid by the person that requests it or by the estate. And then interested person, which is something I think we've talked about a few times, but it's specifically defined in statute 731-201. And it's any person who may reasonably be expected to be affected by the outcome of the particular proceeding involved. And that may change depending on what petition is being heard or at what stage of the process that you're in. And generally that could be somebody that was named a beneficiary under a prior will or trust, but isn't in the later will or trust in a will contest, a surviving spouse that may or may not be named in the estate plan, and creditors are considered interested person or parties as well.
Okay, one more thing, and this is a recent, I think it was October 2021 change in the law. If you were convicted of elderly or disabled exploitation in any jurisdiction, foreign or domestic, you are also disqualified from serving as PR of the person's estate that you, of any estate, I apologize. So keep that in mind too. It's probably a felony anyway, but that's one thing that came out of the recent legislative amendments in 2021. All right, so we talked about this a little bit before, but let's dive deeper on non-probate assets versus probate assets. So although you do need a determination of homestead from the probate court to have a homestead be protected homestead if it was just owned by the decedent, it is technically a non-probate asset. So as soon as that order of determining homestead is entered, that item, that asset falls outside of the jurisdiction of the court, and it is no longer considered to be, I guess, accessible to the court. So at that point, the owners of the probate, whoever the heirs are, the beneficiaries are going to have title to that property, and it will no longer be a part of the probate administration. Generally, probate is defined under Article or Section 4C, Article 10 of the state constitution. And it is generally owned by the decedent. It is where he or she resided and had a good faith intent to live there long term or make it their permanent residence. Property that's titled jointly with the decedent with right of survivorship or tenancy by the entirety is also a non-probate asset. Property with a beneficiary designation for distribution after death. This can be bank accounts. This can be a life insurance. This can be an annuity. Anything that you can designate a beneficiary on that has that beneficiary designation is going to be a non-probate asset. Now, if for any reason your designation of beneficiary fails and you don't have alternates, I'll give you an example. When somebody gets divorced and doesn't change their ex-spouse as their beneficiary, there's a statute that says the ex-spouse is treated as predeceased. At that point, the ex-spouse no longer gets the life insurance policy. If there was no alternate, the life insurance policy would go to the estate and would go through as a probate asset. That's one of the tricky things and exceptions with life insurance policies. And another thing is a life estate deed or a ladybird deed. We talked about this a little bit. You're going to have a life tenant. The life tenant's going to be responsible for the majority of the expenses during their life. And then you're going to have the remainder people or remainder men that are going to inherit the property or take the property by operation of law upon the death. All you have to do to change title on property that's jointly owned with right of survivorship or life estate with remainder to somebody else who's still alive is record a death certificate with the county. That recording of the death certificate with a cover page that links it to that property, say in the cover page, here's the legal description, it's being recorded as to this particular property, should update the title. If that doesn't do the trick, a letter to the property appraiser with the recorded copy of the death certificate should do the trick. And I've had it happen both ways, where it happens automatically or it doesn't. And sometimes you'll see that the property appraiser already knows the person passed away and they change somebody's title to estate of when it's in the name of just one person. So keep that in mind. You may have to take extra steps to get the property appraiser to move a little bit quicker, but it's accomplishable by just recording that death certificate if there is a live person who is set to get it by operation of law. Another non-probate asset is trust assets or our trust assets, as long as the trust is fully funded. If the trust wasn't funded during somebody's life and they put nothing in the trust, but let's say they had a will that was a pour over will, and that means that everything was left to a trust and pours over into the trust bucket, and they didn't put the name, they didn't change the name of their assets, real estate, bank accounts, designations of beneficiary, what have you, to the name of the trust. Even if there's a trust existing, you're still going to have to go through probate to get all of that stuff from the name of the person to the name of the trust. So if somebody has a trust and they don't fund it, it's worth less than the paper it's written on at that point, because you're still going to have to spend money to go through probate. Probate assets are going to be anything that's real or personal and is titled solely in the decedent's name at the time of death. So if there's somebody else and there's no right of survivorship, there could be, for example, in real estate, if Elsa and I owned a property together, but we didn't have rights of survivorship, my portion of that property would still have to go through probate if I passed away. And then it would go to whoever I designated in my will or whoever is my heir under intestacy law. So keep that in mind. Just because you have a joint tenant doesn't mean that they have right of survivorship. In Florida, that's not a default. You default to just joint tenancy, and the right of survivorship has to be specifically stated in the instrument giving title.
Okay, so costs and attorney's fees and compensation are somewhat covered by statute, and it's also something that is heavily litigated in certain cases. So costs and attorney's fees are addressed in statute 733-106 and 733-707. And it generally says that the personal representative's costs and attorney's fees, as long as they are reasonable, should be covered by the estate, unless the personal representative and beneficiaries come to some other agreement. That any attorney or party who rendered services that benefited the estate may be entitled to costs and attorney's fees. So let's say that you bring a will contest because you don't think that the most recent will is valid and the court ultimately agrees with you. It could be determined that you helped to benefit the estate by carrying out the decedent's true wishes, and you may be able to recover reasonable attorney's fees and costs from off the top of the estate. And then the court also has discretion to assess costs and fees from a specific part of the estate or trust. So the court can say, if they believe that there's reason to do so, that, the costs for the personal representative should come out of this beneficiary's portion of the estate because a portion of them should come out of this beneficiary's estate because they were the one that prolonged the litigation. Or there could be a bunch of other reasons why that could happen. And then the personal representative is technically entitled to some reasonable compensation for their time and efforts. And there's also an additional portion of the law that talks about extraordinary fees to compensate the personal representative. And then the personal representative's attorney, as I mentioned, should be entitled to fees from the estate. Now, obviously, if the personal representative is the sole beneficiary, it ultimately doesn't really matter. And then there's also a statute that governs the order of payments and expenses and obligations of the estate. So statute 733-707 is the statute that governs that. There are 8 classes of types of expenses that it covers, and it requires the personal representative to pay the obligations in order. So if there's not enough for all of the classes, you have to pay the first class first, which is the expenses of administration, compensation of the personal representatives and their attorney, and their costs. And then class 2 is reasonable funeral, interment and grave marker expenses, etc. And it goes on and on through 8 different classes of expenses. And all of it is ultimately comes down to reasonable costs, reasonable fees, and there are some caps. So for example, the cap for funeral expenses is in total $6,000. So that's definitely something that you want to look to determine, you know, is there going to be enough to pay the class 8 expenses, or who gets paid first, and where those expenses are going to come from.
So as we mentioned before, there's something called adversary proceedings in probate, and not every proceeding is going to be adversary. Not every adversary proceeding, or not every contested proceeding, is automatically adversary. Some have to be declared. So in Florida Probate Rule 5.025, you'll find a list of which proceedings are specifically automatically adversary. So those can include the establishment of a lost and destroyed will. It can include a petition to remove a personal representative or to revoke probate. And if a proceeding is not automatically adversary, but you are contesting something, for example, if there's a petition for administration filed and you disagree with it, with the will, and you object to it, and then you file a competing petition, a petition for administration is not automatically adversary, but you can declare it adversary and make the civil procedure rules apply by making a declaration or filing a declaration and serving that on the interested person, on the interested persons, that the proceeding is adversary. There is a time frame and there is a way to do that correctly. So if it's not automatically adversary, you have to, in the responsive pleading, declare it as adversary and file that declaration of adversary proceeding. Otherwise, they can argue that you waived it. But just look at the rules for the particular proceeding that you're dealing with and make sure, is this adversary already? If it is, then I don't have to worry about it. If it's not adversary, do I want to file a notice of adversary proceeding along with it? And that can be a strategic decision. If you just want the probate rules to apply and you don't want to open up the application of the civil procedure rules, if they're not automatically triggered, then you don't do the declaration. If you do, then keep in mind also that some courts, and the majority of courts, will require you to file a separate proceeding for the adversary proceeding. The reason for that is you have the probate case number, and then you have the adversary case number. And once the adversary matter, that proceeding in particular, is taken care of, they close out that case number and they continue with the administration in the ordinary course. Some judges and some courts will allow you to have adversary proceedings within the original case number. We've had that happen, but just be mindful of those requirements, because you may have to file a separate proceeding and pay a separate filing fee to declare something adversary and to start that adversary proceeding. There is also the opportunity for the judge or the court to declare something adversary by court order. And they can do that either sua sponte or upon somebody's petition. And then there's the notice and procedure for adversary proceedings. You have to give formal notice in adversary proceedings. So that's another thing that you should keep in mind when you're determining whether you want to turn something that's not already adversary into an adversary proceeding, because then you're going to have to spend money on postage. You're going to have to spend on certified postage. You're going to have to send people the formal notice document, and they're going to have the 20 days to respond.
So in some cases, there is litigation beyond just, determining who the personal representative is going to be and then having the state administered. And so we're going to touch on the most common litigation issues, although there are many more. So generally, disputes arise between a second marriage surviving spouse and the children from the prior marriage, because ultimately things may have changed later on in life, and there may be many reasons why a dispute may come up. A lot of the disputes are about whether or not certain estate planning documents are valid, and we'll get into that in just a moment. And then also, as I mentioned, disagreement over who should be the person appointed to be the personal representative. And so litigation can generally start in two different ways. So a petition for administration is filed by the person who wants to commence the probate administration. And then a beneficiary or an interested party might file an objection to that petition for administration and a counter petition saying, no, that will's not valid, or I know of a newer will, or, I should be the personal representative because I have preference because of this or that. Or if the will has already been admitted to probate or intestacy has already started, you can do a petition to revoke probate, which would then pause everything in terms of the administration and deal with the litigation issues. So the most common causes of action in will contests or trust contests, which are generally sort of the same, and that even applies to things like contesting the validity of a deed, granting real property, or beneficiary designations of a bank account, are lack of testamentary capacity, which basically says that at the time that the decedent executed a legal document, they did not have the testamentary capacity to understand who their heirs were, what their assets were, and what the practical effect of that document would do. And it's honestly a pretty low standard, and it's pretty hard to prove unless you have just like a lot of clear-cut evidence. And so that litigation can go on. It will require an expert on a lot of cases, or medical records, or both, as well as any lay witness observations and things of that sort. The second is undue influence. And there's a lot of case law that comes into play for undue influence claims. One of the most famous cases is In re Carpenter's estate from 1971 by the Supreme Court. And Carpenter lays out several factors or elements that would create a rebuttable presumption that undue influence occurred. So some of those factors are whether the beneficiary in the contested will was present when the will was executed in the lawyer's office, or maybe drove the person, present when the beneficiary. That's what I found. Sorry, my Siri just went off. The beneficiary was present at times that the testator said, I want to make this change in my will. Maybe made an appointment for that testator to meet with their attorney to make that change. Knows what the new will say before it's even executed. Giving instructions to the attorney on behalf of the testator, or keeping a copy of the original will if they are one of the main beneficiaries of the new document. So those are some of the factors that can come into play. There are a few other cases. One actually precedes Carpenter, and then there's a case after Carpenter that comments on it that essentially says that in the case of spouses, there won't be a presumption of undue influence because one of the elements necessary to create that presumption is a confidential relationship, meaning like a close, trusting relationship. And the court essentially said that with spouses, the nature of their relationship is that they trust and rely on each other and do things together and make decisions together. And so it wouldn't be right to presume that a spouse unduly influenced the other spouse into making a will just because they drove them or were present with them or had a relationship where they helped them with their daily activities. So you can still establish undue influence, but it is harder when it relates to a spouse. And then something that the law is developing is case law related to, okay, well, what about other people in the family? And that there's a number of cases that I've listed here that are actually probably one of my, I think, the most interesting areas of probate litigation. But dealing with, okay, well, this child lived at home with mom, took mom to all of her appointments, helped mom pay her bills out of necessity. And at what point does that become just like a helpful, dutiful child versus somebody who's going too far? Then another cause of action that's common, but really hard to prove, is duress, which essentially is to, threaten or force the testator to make a change in their document or to execute a document in exchange for something or to avoid something. Breach of fiduciary duty, and fiduciary duties are often easier to establish if there is like a power of attorney, a healthcare surrogate, if the person was a trustee. And if the spouse or the child and the dutiful child argument comes up, that's something that you may start to incorporate is, okay, yeah, they were a dutiful child, but they also had fiduciary duties to mom. They were also the power of attorney for mom. They were also maybe the trustee for mom. And then civil theft is pretty common, and under civil theft, you could be potentially entitled to 3 times the damages of what was allegedly stolen if you can prove the claim. So that can be a really powerful tool in litigation. And then finally, tortious interference with testamentary intent, which is not really something that's commonly litigated in probate cases because it's generally an equitable argument that is sort of a last resort if the other claims failed, but sometimes it does come up that the other claims are not relevant, and maybe the only relevant claim would be tortious interference with testamentary intent. And basically that is to say that you did something to change what mom really wanted that amounts to a tort, and so you shouldn't be a beneficiary, or the amount of beneficiary ultimately claims. Another common litigation issue that comes up is establishing a lost or destroyed will. So if we know that mom executed a will in 2010, but we can't find that original document, there is a presumption that mom may have destroyed that document or otherwise caused it to be revoked, and that destruction would be equivalent to revoking that will. That is a rebuttable presumption, and there's certain steps to litigate that issue, and there are specific statutes and rules regarding the petition to file if that's something that you're trying to claim, and what should be considered if you're litigating that issue. And then finally, one of the more common issues is whether or not the personal representative maybe becomes unqualified because they become a convicted felon and they're refusing to step down, or there becomes a conflict of interest with the personal representative and they're refusing to step down. So you may be trying to remove that personal representative from their appointment.
So here are some general resources for you, and I'll go through some of the concepts to explain what they are for purposes of finding where you can learn more about certain concepts that come up in probate. So some of the common issues and the sections are here. No contest clauses, sometimes they're called interorum clauses, are illegal in Florida. They're not enforceable. So if there's a will or a trust that says, if somebody contests my will, they're not entitled to get anything from my will or from my trust, that's not going to be enforceable. And you can find that at 732-517. Agreements concerning successions. Basically, this is a contract to make a will. Unless the will is in writing and the contract is in writing, you're not going to be able to enforce that. You can find more, and that's very rare for it to come up. I've never really had to deal with that. You're gonna find that at 732-701. Pretermitted children is something that comes up more frequently, and a pretermitted child is a child that was born after a will or trust was created and not included by accident in that will or trust. Obviously, didn't know you're going to have kids. A lot of people do put a provision in wills or trusts that includes afterborns, just as a general concept. So that won't be an issue with a pretermitted child. But if you just name one child, and I've had this happen, had serious litigation over it, just name one child in the will or trust, and then there's other children either from same relationship or other relationships, they can claim what they would have been entitled to had they been born at the time of the will or trust. So they get the intestate share of what they would have been entitled to. Adoption and paternity are also addressed. There's timeframes to establish that somebody is your father or your child, and there are timeframes to establish an adoption. Obviously, has to be done before the person's death. And adopted children, if they're formally adopted, are treated as your children for purposes of the probate code. So they will be entitled to inherit. They will be treated as interested parties in a probate proceeding. There's also the rights to protected homestead, and there's provisions that deal with homestead protections for spouses and minor children. Florida law favors keeping a roof over the head of a surviving spouse, male or female, and a minor child, so that they are not displaced at the time of the decedent's death if for any reason the spouse is not on title, or the children are not on title. So what needs to happen is, if somebody does devise a property or leaves a property to someone other than their spouse and they're married, or even if they leave it to their spouse and they have a minor child, there are those restrictions on alienation. If you have a spouse or minor, you can't leave it to anyone else. If you only have a spouse, then you can leave it to your spouse. But in that case, what happens is those devices get undone, and you end up going to court for relief for that, and you declare the homestead, and you say that the device was improper, and you explain it in your petition, and the court enters an order rectifying that issue and giving the homestead to whoever is entitled to it under the law. Exempt property is something else that comes up. It's a useful tool for protecting things against creditors' claims and for sale for creditors, satisfying creditors' claims. So the exempt property rules or the statutes allow you to declare up to $20,000 worth net value of household furnishings and furniture as exempt property. So that way it can be claimed by the surviving spouse or any children that live in the home, and they can keep that and not have to worry about it being sold off for creditors. You can also declare up to 2 vehicles, and there's other pension benefits that are in the statute, and you can locate that at that 732-402 that can be exempt from creditors' claims. In terms of the vehicles, there are some weight and size restrictions, and the vehicles have to have been used by the decedent or the decedent's immediate family for day-to-day use. So a commercial vehicle probably not going to qualify under that unless it was the family's only vehicle and it was also a family vehicle for day-to-day use, and it fits the size requirements. So give me 1 minute.
Okay, I think we froze and we were cut off. Is everyone able to hear us? Can someone confirm in the chat?
I can
I'm
hear
just sending a chat message. Are we live?
you. Yep, I can hear you.
Okay, thank you.
You're
Looks
back.
like there was a lightning strike. So
All
we were
right.
talking about exempt property. All right, I'll go right back to it. Thank you, everybody. So exempt property, there's the vehicles, there's the furnishings. You can declare that exempt from creditors' claims. Another really useful tool is the family allowance. Not enough people use this, and sometimes I'm surprised by attorneys who represent a spouse or dependent children, and they're asking for money, but they don't file a petition for family allowance. So it's really up to $18,000. It can be a lump sum payment, or it can be in installments, and the surviving spouse can use that or can ask for that to basically maintain him or herself and any children during the pendency of the probate administration. It's kind of like a bridge the gap thing, like kind of like the bridge the gap alimony in family cases. It allows you to take care of your family if you can't access the decedent's resources for some time because there's creditors periods or creditors claims that may come up. This is exempt from creditors claims, and it is also in addition to any other benefits that the spouse may receive under intestacy. There's also the pretermitted spouse. Similar to pretermitted children, we've had cases where somebody does a will or a trust and doesn't think they're going to remarry, and what happens, lo and behold, 5 months before they die, they marry somebody else, and they don't include them in the estate plan because they never changed it. And that's really the importance of being in contact with your estate planner and making sure to keep them apprised of any life events so they can advise you as to what to do. So the pretermitted spouse can go ahead and claim that they are pretermitted, that they were omitted in the will, and if they were included in the will for any reason, they will have to show that they were not included in contemplation of marriage. So that's a really important distinction there. If they were together and they were going to get married and they were not included in the will as a spouse or or obviously not named a spouse, then they will have to prove that it wasn't in contemplation of marriage. All right, so we also have the elective share. The elective share is similar, and it's an alternative for when you're disinherited. You can take up to 30% of the decedent's elective estate. And it's kind of a complicated calculation, but it's laid out as best as the legislature could lay it out in Chapter 732 under 201 through 228. You basically get to pick if you're disinherited and you are considered pretermitted. If you are in that position where you were not included in a will, you can choose between the elected share and the pretermitted share. And that pretermitted share is going to be the intestate share, which can either be the whole estate or half of the estate, depending on the circumstances. Then there's also rights wrongfully procured, pre and post nuptial agreements. You can waive spousal rights to an estate or in an estate in a valid pre or post nuptial agreement. And then 702 gives you how you do that. You need 2 witnesses unless there's certain circumstances. Then there's also the Slayer statute. The Slayer statute goes into not benefiting from your own wrongs. And if you procured or assisted in or committed murder or assisted in the death of the person that you are set to inherit from, you're not supposed to benefit from that wrong. So there are disinheritance penalties, like I mentioned, and there are also penalties that you can't serve as PR if you are the slayer. So that body of law has changed in the last year, so it's important to keep up on that if that's an issue. There's also exploitation, which has also changed in the last year, and it kind of goes hand in hand with the Slayer statute. It also includes disinheritance penalties as well, and you can have the Slayer statute and exploitation statute applied if there is a conviction or by a greater weight of the evidence if there's no conviction. You're on mute.
This is the last slide of our probate section of our presentation. And then if we have time, we'll get into some of the guardianship and exploitation stuff. But so if there was never litigation or once litigation ends, the court will appoint a personal representative or co-personal representatives, or maybe in some situations, a professional such as a curator or something like that. And that person will, and hopefully to some extent, someone has been throughout the litigation process, marshal the assets and take an inventory of what exists and make sure everything is protected and that creditors are getting dealt with. So one of the first things that happens is that an initial inventory is filed, basically saying, as far as the personal representative knows, these are the assets that make up the estate and their approximate value. The personal representative is also going to take, gather all of the assets. Maybe there's a property that's being rented out. They're going to collect the rents. They're going to maintain any property that needs to be maintained. And they're going to notice and defend against creditors' claims where appropriate or pay them where appropriate. So that'll include, checking safe deposit boxes, locating tenants, locating bank accounts. And what they'll do generally is take all of the liquid assets and put them into what's called a restricted depository, which is a bank account that is monitored by the court so that that property is kept safe. Something that you should also check if you're the personal representative, and especially if the decedent has been dead for some time, is Florida unclaimed property, such as, for example, they may have had a bank account that has never been claimed, and so the bank may send it to Florida unclaimed property, and the way to check that is to go to floridatreasurehunt.gov. There are certain perishable property or business interests that need to be managed. For example, if the decedent had a small business that could continue to make money or which will lose value significantly if it's not kept up, somebody needs to get on top of managing that business, either to continue it or to liquidate it or to otherwise, keep as much of the value as possible for the beneficiaries. There may be payments that may need to be made for a mortgage or for electricity bills that the personal representative needs to be on top of. Sometimes things need to be sold, and converted into cash assets, and generally that requires court approval and either formal notice to interested parties or consents and waivers or consents and joinders to accomplish that. One thing that is very important to keep track of as a personal representative is that dealing with creditors has a number of steps and very, very strict deadlines. So commonly, one of the common deadlines that comes up repeatedly is 30 days, but they are very strict. So you're going to publish notice in Miami-Dade County. We do it at the Daily Business Review, but each jurisdiction is going to have a different place to publish notice. If there's creditors that you know of because they're sending bills to your house or just because you know there's a mortgage, you may need to notice that creditor specifically by certified mail. They will have an opportunity then to file what's called a statement of claim to say, hey, I'm owed this much money. Depending on the validity and the proof that comes with that statement of claim, you as a personal representative or could be another interested person may want to object. If you're going to object, you have 30 days to do so. Otherwise, that claim will need to be paid or settled by the personal representative and the funds in the estate. And then if an objection is made, the creditor has 30 days to file what's called an independent action, or essentially a completely separate civil case to try to claim what they're owed or allegedly owed. And then the personal representative is going to do an accounting, let everybody know what are the assets. Once they've gotten a hold of everything, the beneficiaries and interested persons will have an opportunity to object or to say, you know, I think there's more out there, or I think that there's an issue with what you put in there, or they can waive that process altogether. And then ultimately the assets will be distributed and the personal representative will be discharged. One question that we were sent is, what is the typical duration and cost of a probate case? And that is incredibly difficult to answer. I would say for summary administrations, it could be a couple of months, or it could be 6 months, it could be longer. For a formal administration, it could be between 6 to 8 months on the very low end. And if there is litigation, it could be a year or years, or I know of a case that has gone on for about 5 years because it's a very large estate and people are very deeply upset about some of the issues along the way. Okay, so that concludes our probate portion. I don't know if we're going to get to the guardianship, but we can get into some questions and we'll include the guardianship and exploitation slides so that you guys have those if you encounter them.
Awesome. And I think you both did a fantastic job of answering most of the questions. If I'm repeating any you answered, I apologize. It's just because I'm, listening, but also responding to some things that come through. So that last question that we just got in now, that says, can you report the number of days to object to statements of claim, please? Can you repeat? Sorry, did you already answer that one?
So it's 30 days. You have 30 days to object to the statement of claim, and then they have 30 days to file an independent action.
All right. And then the only other one that I saw that came in, not to everybody, it came to the host and panels, is, so I'm sorry also if you answered this, it was more in the beginning. Is there a statute of limitation for bringing a probate case for an intestate estate?
So there is no statute of limitations to open the estate. But what you'll find is that there's a statute of limitations or statute of repose as to creditors' claims. So if, and this is very unusual, but if you are opening an estate for purposes of collecting on a creditor's claim as a creditor, you're going to have to do it before the 2 years are up. If you are opening the estate on behalf of the family or the heirs or beneficiaries, there's really no deadline by which you need to do it. Keep in mind the deadline of the will for deposit of the will and the potential for attorney's fees if you don't do it on time and it affects somebody else. But other than that, there's really, I mean, I've seen people wait 3, 4, 5, 10 years to open an estate and not realize that they need to do it. And it's not a huge issue. So just keep the creditors thing and the deposit of will in mind. I do have a 1:30 Zoom, unfortunately, so I will have to jump off. Elsa, if you want to continue as far as you're able to, or if you want to just address any other questions, I just want to thank you guys very much for the opportunity to present to you and to show you what we do. And if there's any questions after this that remain unanswered, feel free to reach out to us. We're always happy to be a resource.
Thank you so much, Gia. You're getting in the chat. What an excellent presentation this was.
Thank you.
We appreciate you so much. Thank you for giving us some of your time.
Thank you. Take care, everybody. I'll leave you with Elsa.
All right, bye, Gia. Thank you. So what I'm going to do is I am going to just post in the chat the CLE number. If there are any folks that do have to, drop off or anything, it's in there. It's 2207102, N as in Nancy. Again, this will be provided in the email as well. So with that, we have a few more minutes. I don't know if you want to try to, give us a summary or give us, we appreciate that you will have the slides for us.
Sure. So one more thing on the statute of limitations, there are going to be some statute of limitations issues that would apply to things like challenging a deed, and those would be under general statute of limitations that you'd run to in any other situation. I'll just, can you help me? Okay, I'm just going to share my screen. Gia's going to help me with this.
All right. And no rush on our end. Folks will stay on as long as so no rush on our end. It's all what you can give because you're donating your time speaking to us.
We're happy to do it. Just want to make sure I leave Elsa in good hands when when I go over there. Right, so I'll leave you the camera here. And then can everybody see the presentation?
Yes.
Okay, perfect. So now you'll just go like this. Okay, perfect. We get to the next one. Oop, went too far. There you go.
All right, I'm just going to sort of speed through guardianship and exploitation just in case, so you know where to look if it comes up, and then I'm happy to stay on and answer questions, but I don't want to take up people's time either. So guardianship cases are generally when somebody has either a developmental disability or because of old age or maybe dementia, something like that, they're no longer able to manage either their personal affairs or their property or maybe both. And also it usually comes along with suspicion that maybe somebody's trying to take advantage of that person, or maybe property's getting lost or misspent because that person isn't able to deal with things anymore. So primarily all things guardianship related, you're going to go to chapter 744 of the Florida statutes. And again, how to file a petition, the procedure for the hearing and the determinations and what needs to go in the court order are all going to be in those statutes. I'll highlight a couple of them. And then the other things that will come into play are powers of attorney and other healthcare directives. So those are going to be in chapters 709 and chapter 765. Of course, all the other types of law that we discussed earlier are going to apply. There's a number of other sort of related things that come up with guardianship, like guardianships of minors, guardian advocates for people with disabilities, Baker Acts. Most probate and guardianship practitioners don't really deal with those specific matters unless that's something that they've chosen to really specialize in. I put the statutes and references there for people just so to be aware or to know where to look if that comes up, but it's generally not something we super typically deal with as probate practitioners. One thing that was very confusing for me when I started is that with probate cases and guardianship cases, when you have a probate case and you're just starting the administration, it's going to have one case number. And if it becomes adversary, it may have another case number. And the same thing happens with guardianships. So when the petition for determination of incapacity, which is how a guardianship starts, is filed, it's going to have a mental health case number. A case number in Miami-Dade, at least it's MH, and it's probably different jurisdiction by jurisdiction. But those proceedings are completely confidential, and it stays under that case number until a guardianship is created, if one is created. And then it becomes a guardianship number, and it's treated with the same amount of confidentiality as other cases. Venue, again, is generally going to be where the person who's allegedly incapacitated resides. Sometimes the person is lost, unfortunately, and then the the guardianship or incapacity proceeding will begin where they're found, and it may be transferred. There is such a thing as voluntary guardianship for the property, and that has a different set of procedures and who needs to be noticed. So that's in statute 744-341 and rule 5.552. And then there's sort of contested versus uncontested guardianships, where uncontested guardianships are pretty rare, but it generally is just the person who is alleged to be incapacitated might be challenging it and going through really asserting their due process rights, whereas contested guardianships might have other family members saying, no, mom is fine, like I take care of her, whereas another family member is saying, mom is not fine, you're taking advantage of her, and it gets into more litigation. So there's some additional statutes and steps. One thing to highlight, I think, is that once a petition to determine somebody is incapacitated is filed, but while the proceeding is pending, before the judge makes a determination on that, before the judge opens a guardianship, the judge can create what's called an emergency temporary guardianship. And that's essentially, that person is going to do the same things as a guardian would do, but it's a limited amount of time, and it's a little bit more strict in terms of what the procedures are, because the alleged incapacitated person hasn't lost any of their rights officially yet. Okay. A person who is alleged to be incapacitated is entitled to an attorney. So generally the court will appoint an attorney for that person. There are certain requirements that you have to have in order to be on the wheel to be appointed to represent an alleged incapacitated person. And there is changing case law and conflicting case law on whether or not somebody who's alleged to be incapacitated can hire their own attorney without the court having at least some preliminary finding of their ability to contract and whether they have the capacity to do that. And that is because sometimes, as you can imagine, somebody who's trying to take advantage of them is really the person who has hired the attorney for them, and it can get very tricky. So one of the main statutes that you're going to want to look through, which really lays out the procedure very well for what happens after a petition for determination of incapacity is filed, is 744.331. And that's going to have a lot of the information you're going to need. So once a petition for determination of incapacity is filed, generally speaking, another petition called a petition to appoint a guardian is filed. And that could be that I'm asking the court to appoint me the guardian of my family member, or it could be that, you know, we can't agree, so we've all agreed that it's okay to hire a professional guardian, but obviously that has to be paid for from the alleged incapacitated person, or what they eventually are called as a ward if they are determined incapacitated assets. And for people that do not have money, there is an office of the public guardian, and you have to ask the court to appoint a public guardian, which is paid for by state funds. So again, once a guardianship is created, the guardian is going to have to manage all of, you know, if it's a guardianship of the property or a guardianship of everything, is going to have to manage that person's assets. If it's of their person, they may have to manage their care, and all of that has to be monitored to some extent by the court. And then the last area that I'm going to touch on is exploitation of elderly and vulnerable adults and what to do. I think that's just something that might come up more for legal aid practitioners, and it's an area of law that's sort of exploding right now. It's very interesting. Because the elderly population is growing in Florida and housing is getting more challenging as prices rise, and there's been more awareness of people being taken advantage of either by caretakers or family members or the cleaning lady or whatever the case may be, this area of law is really developing right now. So a newer procedure that was created is an injunction. And just like an injunction for, say, domestic violence or some other kind of injunction, you can petition the court for a ex parte temporary injunction pending a more permanent injunction. And what the judge can do is obviously enjoin anyone from exploiting the vulnerable adults, as well as freezing their assets, giving them sole possession of a property. I've had a case where the judge ordered that the vulnerable adult no longer have access to drive because she was driving and endangering herself. So different steps can be taken through an injunction to protect a vulnerable adult. And there are restrictions on who can file that petition. And so all of that's going to be available in Florida Statute 825-1035. Other remedies could be to have a civil lawsuit to try to recover assets of the vulnerable adult. So let's say that a friend has been taking advantage and stealing money. You may want to try to recover that through a civil theft action, or maybe it's a power of attorney who's been using the power of attorney to benefit themselves. And again, that civil theft has the potential to give treble damages, so it can be a really powerful tool. Criminal prosecutions are very tricky with elderly exploitation. I think a lot of departments and state attorneys' offices are trying to work on doing a better job of this, but it's something that in my personal experience has been really hard to get the police to intervene or get prosecutors to prosecute these cases. One thing that can be done is you can file a report with the Department of Children and Families, and they'll send somebody from Adult Protective Services to investigate the situation and create a report on it, which is something either you can use or maybe the Department of Children and Families will take some action. A lot of times exploitation cases go hand in hand with creating a guardianship, and the petition for injunction can be filed directly with the petition to determine incapacity and the petition to appoint a guardian. And sometimes it's as simple as, okay, mom is not completely gone. She still has some capacity, but it's time to put some protections in place. There are estate planners and other elder law practitioners who specialize in what somebody that is elderly will need and how to make sure that they're protected. And there are also practitioners who I've seen that maybe make questionable choices and create documents or something for people with an exploiting party involved, which is something also to watch out for. So that is the end of that. And then we just have some resources here that you might find useful. Westlaw and Lexis have a lot of forms for petitions and how to deal with creditors and things like that. And then there are these books through the Florida Bar, which are also available on Westlaw. So this is called Litigation under the Florida Probate Code. There's also Practice under the Florida Probate Code and Florida Guardianship Practice. And they're sort of like the Bible of any question you have will likely be in here, and it is online on Westlaw. So if anybody has any questions, I will be happy to stay and answer them for a few minutes. Other than that, I'm all done, and I'm sorry for going over.
Awesome. No, thank you so much. So many folks in the chat said thank you for offering this great basic webinar. Thank you so much. I'm telling you, this is one of these presentations that folks are going to go back and watch as they encounter issues and as their cases develop. So we can't thank you enough for giving us some of your valuable time and for sharing these resources with us. Thank you. I don't see any questions in the chat. What I will say is, you don't even know this, but it was very appropriate that you ended on exploitation of seniors, because on Monday we are having our next webinar that is being presented by Elder Options on what is it called? Abuse later in life, financial exploitation of why seniors are vulnerable and how to intervene. So I did put timing, right? Perfect timing. And I didn't even plan it that way. So, so I did drop that into the chat for those who are interested, and I will follow up with that in the email as well. With that, Elsa, folks who are still on, you might not know, I worked with Elsa at the Public Defender's Office. She was the first person I thought to ask to speak on this topic, because all throughout she does, her passion oozes through, her attention to detail, and her professionalism. So thank you so much, Elsa, for doing this. Thank you so much to Gia. She was fantastic. And with that, we'll let you get on with your day. I don't even know if you got lunch yet. So
no, I'm going to now. Thank you, everybody. Thank you, Alexis.
All right. Talk to you soon. Bye, everyone. Have a great rest of your day.